Picture a busy pub. A customer knocks a pint glass off a wooden table and it shatters on the floor. Is this simply a clumsy accident, or does it cross the line into something more serious? Under civil law, the pub owner might seek monetary compensation from the customer to replace the broken glass. This layout shows the key distinction. A criminal offense investigates whether the act deserves state punishment, rather than mere compensation. To elevate that shattered glass to the offense of criminal damage, the law requires proof of a specific state of mind, that the customer broke it deliberately or recklessly. This highlights the consensus definition of a crime. It is a public wrong against society itself, rather than a private dispute between individuals. While civil law focuses on making the victim financially whole, criminal law demands a formal sanction, such as a fine paid to the court or a sentence of imprisonment. Because it is a public wrong, criminal proceedings in England and Wales are usually brought by a public entity, the Crown Prosecution Service, or CPS. This means that once the CPS lays charges, a prosecution can proceed to trial even if the original victim decides they do not want to pursue the matter further. Distinguishing this public wrong from a private civil tort is the necessary first step in diagnosing any legal problem scenario. What specific criteria drive society to label a behavior as a public wrong? Criminalization is not a static rulebook. The law shifts to reflect the changing opinions and beliefs of society at any given time. The 1957 Wolfenden Committee report articulated one major school of thought, the Utilitarian Approach. This approach argues that conduct should only be criminalized if it causes identifiable harm to persons or property. Offenses like murder or theft fit cleanly into this category. The opposing school of thought is the Moralist Approach. Moralism dictates that conduct should be criminalized strictly because it is considered morally blameworthy, even if no specific harm to the public can be identified. The tension between these two theories was tested at the highest level in the 1994 case of R versus Brown. The court had to decide whether private consent could act as a defense against an assault charge for acts that were physically harmful but mutually agreed upon in private. The House of Lords split on the issue. Lord Templeman's majority ruling applied a strict moralist stance to uphold the convictions, while Lord Mustill's minority judgment championed the utilitarian view. Examiners test this philosophical divide to see if you understand the societal intent behind a statute, rather than just memorizing its rules. Once a behavior is classified as a crime, abstract philosophy gives way to the physical reality of the courtroom. The procedural starting point is Section 17 of the Magistrates' Courts Act 1980. This diagram shows how the Act creates a rigid, tripartite classification system for all offenses in England and Wales, summary only, either way, and indictable-only. We see here the venue for the first category. Summary-only offenses are the least severe crimes and are handled exclusively in the magistrate's court. These cases are typically tried by 3 lay magistrates who lack formal legal qualifications, and their sentencing tower is strictly capped at a maximum of 6 months' imprisonment for a single offense. This represents the other extreme. Indictable-only offenses, like murder and rape, must be tried here in the Crown Court before a judge and jury. Because of their severity, these crimes bypass a magistrate's trial entirely. Between these two extremes lies a complex middle ground, either-way offenses, like theft or burglary. Determining the trial venue requires 2 steps. First, the magistrates assess the facts to decide if their 6-month sentencing limit is sufficient punishment. If the magistrates accept jurisdiction, the ultimate choice of where the trial takes place transfers to the defendant, who may opt for a Crown Court trial, hoping for a sympathetic jury. Incorrectly identifying an offense's classification early in an exam will structurally derail all your subsequent procedural analysis. Beyond the physical location of the trial, we have to look at the internal mechanics of securing a conviction. The bedrock concept of criminal procedure is the allocation of the burden of proof. This is the defendant in Woolmington v. DPP, a 1935 case that established the modern standard. Woolmington claimed his wife's death was the result of a firearm accident. The legal question was, did he have to prove it was an accident? Viscount Sankey delivered a historic ruling, creating what he called the golden thread of English criminal law. The prosecution bears the absolute duty to prove the prisoner's guilt. The defense does not prove innocence. In this diagram, we see the true weight of the legal burden resting entirely on the prosecution. To discharge this burden, the prosecution must satisfy a severe mathematical standard. They must prove guilt beyond reasonable doubt. So, what is the defense's actual responsibility? They carry what is known as the evidential burden. Consider a hypothetical scenario. Ellen is charged with assault for hitting Oksana. Ellen takes the witness stand and claims she only hit Oksana because she was about to be slapped. Ellen only needs to provide some evidence to make self-defense a live issue for the court. She doesn't legally prove it. Once triggered, the heavy legal burden instantly shifts back to the prosecution. They must disprove Ellen's claim of self-defense beyond a reasonable doubt. Any student who writes "the defendant must prove self-defense" completely misunderstands the golden thread and will fail the exam question. What happens when a trial court misapplies the burden of proof or makes another legal error? The system provides structural remedies, but the appellate routes are intentionally asymmetric, heavily favoring the defendant. This ascending diagram illustrates the defendant's path. A convicted person can appeal an unsafe conviction or an overly harsh sentence directly to the Court of Appeal. If the trial judge's direction contained a substantive error of law, the Court of Appeal has the power to completely quash the conviction. There is one caveat, known as the proviso. The court can uphold a conviction despite a legal error if they are certain the verdict remains undeniably safe. By contrast, the prosecution's powers to challenge an outcome are severely restricted. The Crown cannot appeal a not guilty verdict based on facts. An acquittal stands. The Attorney General does have limited power, referring points of law to the Court of Appeal for clarification. However, this does not overturn the original acquittal. Even with an appeals process, miscarriages of justice occur. A final safety valve activates only when all standard appellate routes have been completely exhausted. That valve is the Criminal Cases Review Commission, or CCRC. As seen here, Section 11 of the Criminal Appeals Act 1995 established this independent body. The CCRC's specific function is to independently investigate alleged miscarriages of justice. It possesses the unique power to bypass standard procedure and refer historical cases back to the Court of Appeal for reconsideration. This institutional power was instrumental in the exoneration of Sally Clark, whose murder conviction was eventually quashed. The root cause of that miscarriage of justice was a trial that relied on completely unreliable expert evidence regarding sudden infant death syndrome. Analyzing the substantive elements of crimes like murder or theft is a purely academic exercise, without first mastering this rigid framework of classification, proof, and systemic correction.